Hello, my name's Ken Novenstern. I'm a partner in the White Plains and Mount Kisco law firm of Fredman, Bacon, and Novenstern LLP. My partners are Neil Fredman and Ellen Janko Bacon. And I wanted to talk today about the judgment of divorce. Um, we, in divorce actions, when we're working towards settlement in cases, which is what happens with most cases, even though some of them are litigated, ultimately, probably a good 90% plus cases end up settling. And we spend so much time working on the separation agreement that sometimes the judgment of divorce is a little bit rushed and people may not have the opportunity to really get a sense of the significance of the judgment of divorce. The judgment is really one of the two most important documents in a divorce, the other document being the separation agreement. The judgment of divorce has several different components. First of all, it incorporates the separation agreement or the stipulation of settlement so that for purposes of future enforcement, if someone fails to do what they need to do with regard to the overall compliance with the terms of the separation agreement, then the judgment of divorce is the document. That's the court order that's used to hold someone accountable. And so it's very important from an enforcement perspective. The components of the judgment of divorce include other items like exactly what the obligations of the parties are with regard to support, division of assets, and other items like health insurance and the last part of it, well, first of all, with regard to health insurance, once the judgment of divorce is signed, that's really the measuring date for electing COBRA through the employed party's health insurance plan. So it's very important within 60 days from the date of the judgment of divorce for the non-employee to contact the employer and elect COBRA, or else you might lose that opportunity. Finally, there is a provision in the judgment of divorce that talks in terms of giving a party the right to use their prior surname, any prior surname, whether maiden name or prior married name, etc. And I have a case right now where the parties have been divorced for about 5 or 6 years, and my client would like to resume using a different name than reflected in the judgment of divorce. So it's very important that the terms in the judgment of divorce be correct, that if you want to use a particular surname from prior to your marriage, that it not be limited in the judgment of divorce, like my case where it specifically says that the wife may only use a certain surname, and now she wants to use another one. So we will likely submit an amended judgment of divorce so she can do that. So judgment of divorce, one of the two most important documents in a divorce action. Ask your attorney about it early, because once people work out the terms of the separation agreement, often everyone's so worn out that the uncontested divorce papers and the judgment of divorce can sometimes be a bit of an afterthought. So talk to your attorneys. My name is Ken Novenstern. Look forward to answering any questions you might have. Take care.